Hi, everyone. I'm Lee Leppert. I'm the Senior Creative Manager here at the Cromeans Law Firm, and just wanted to thank you all for joining us today. I know everyone's busy, and so we just really appreciate you being here with us today and joining us. And also wanted to introduce Jonelle Oldacre. She's the Senior Associate Attorney here at the Cromeans Law Firm. She'll be leading our presentation and then the discussion and Q&A at the end. I just want to make sure all of you guys can hear me and see the presentation well, so please feel free to send me a message in the chat. Just want to make sure that everyone can hear me clearly and the sound is working well. And I'm also going to ask that everyone remains muted during the presentation portion. We will have a Q&A at the end where you'll be able to ask all of your questions with Jonelle. So you can feel free to unmute yourself then, send us questions in the chat, and we'll be able to answer all your questions for you. So today we'll be discussing how the bonding process works and how best to secure your right to payment. As a subcontractor, you should definitely fully consider the implications of accepting a job that requires a bond and fully understanding all of the risks that are involved in the agreement. So I'm gonna let Jonelle start and go ahead and take it away.
All right, subcontractor bonds. That's what we're talking about today. All right, and I'll just give you just a brief overview of everything I'm going to be discussing. I'm going to go over the background on bonds first, then I'm going to talk about the importance of perfecting bond claims, and then we're going to discuss the major differences between performance bonds and payment bonds, and then lastly, I will discuss the dreaded bond to indemnify against liens. Okay, next slide, please. Okay, so usually subcontractors don't really bother with bonds, right? But occasionally when it comes to the bigger projects, they might find a requirement in their subcontractor agreement to obtain a bond in order to even be considered for a project. Now these are usually much larger projects in which the owner is requesting that the GC provide bonds and also that their subs as well have bonds in place as well. Now, the name of the game here is risk transference. Everyone is trying to pass the risk downstream to limit their potential liability as much as possible. Okay, next slide. All right, and as mentioned, you might actually find yourself in a position as well. If you're contracting directly with the owner, even if you're typically a sub, you will be in a position as a general contractor yourself, and you might find it beneficial for you to require any subcontractors working underneath you to obtain bonds as well. Depending on the type of project and how large the project is, that might be something you might want to look into. This is especially important if you're in a situation where you've never worked with a sub before, or if a GC has never worked with you before. This is the best way to make sure that the scope of work is not over a subcontractor's head. And so it ensures basically that the scope of work is going to be complete. Again, the bigger the project, the more likely you're going to run into bond requirements. Next slide. Okay, now a general contractor, when selecting a sub to work with, they might require a letter from a surety indicating how much the subcontractor qualifies for. This is somewhat similar to a letter of credit, just letting them know that you have the manpower available to complete the scope of work, and that overall you have the capital to get it done as well. Before a surety will issue a letter or even issue a bond, they're going to do some investigative work themselves. They're going to research your company, see how much experience you have, your laborers have, and make sure that you're a good investment, so to speak. Because if there's any issue with the project, ultimately the surety might be on the hook. So they're going to do their due diligence and make sure that you can get the job done, and hopefully no one will come crying to them with any claims in the future. Next slide. Okay, now if a general contractor requires a bond, it's very important that you secure that bond before you get started. Now, you might find yourself in a situation where the general contractor doesn't even request verification or information about your bond before you start work. However, they can ask for this documentation at any point. And if you find yourself working on a project that requires a bond and you haven't secured one, at that point, technically, you're in breach. And if the GC finds out, that could be a cause for termination, okay? And it's just not a good position to be in. So it's very important that you read your contract thoroughly, make sure you understand all the terms and the implications that come along with securing a bond. And if you're not comfortable with purchasing a bond or utilizing that service, definitely reconsider entering into a contract that requires that. And also remember, contract terms are negotiable. If you run into any clause in a contract that you're not comfortable with, talk to the GC. You can always get it edited out, possibly, or talk to your attorney and see if it's a clause that you should be concerned with, or if it's something that you should go ahead and sign up for. Okay, next slide. All right, so now we're going to talk about perfecting bond claims, okay? Now, when it comes to public projects, you may know the federal government requires a bond in place via statute. It's called the Miller Act. That's outside the scope of this discussion. However, the state of Texas has a very similar statute. It's designed to protect subcontractors who are working on publicly owned properties in the state of Texas. Now, usually a mechanic's lien is the primary weapon of choice when it comes to subcontractors who are trying to get paid for work. However, for higher valued public projects, mechanic's liens just aren't available. However, there's another process that you can go through to attempt to get paid in that case. Next slide. Now, the requirement for bonds on public projects is found in Chapter 2253 of the Texas Government Code. All right. Subcontractors that are attempting to recover for non-payment on these types of projects, they have to follow the guidelines that are outlined in this statute. All right, it's very important. It's very technical, very similar to the mechanic's lien statute that's found in Chapter 53 of the Texas Property Code, and that if you technically miss one requirement and then you try to sue on a bond claim, it can be thrown out of court very easily just by missing 1 day deadline. So it's very important to make sure that you're very familiar with those terms, or to hire an attorney that can help you navigate perfecting a bond claim. Okay. Now, the general contractor for prime contracts over $25,000 or $50,000 for municipalities, they have to have a bond in place. If they don't, then at that point you can go after the public entity directly at that point. All right, next slide. Okay, so if the surety, let's say, you've done some work on a public project, you go to the GC or the sub that's above you for payment, and they don't want to pay you. Okay, so at that point, you go to the surety to see if they're going to go ahead and do what they're supposed to do and pay you. If not, unfortunately, your option is to file what's called an action on the bond, which is essentially a lawsuit. Okay. Now, if you want to furnish labor and materials for a public project, make sure you get a copy of the bond before you start work. You want to have all your ducks in a row before you even step foot on the project, so you can make sure that if any issues occur with failure to pay, you can act quickly. Because as mentioned, the timelines for perfecting a bond, they're very strict. So you want to make sure you can jump at the first sign of any kind of payment issues. All right. And if the general contractor fails to pay for labor and or materials furnished, I think, oh, could you go back? I'm sorry. That's fine.
Sorry about that.
No worries. So as I was saying, if the bond is not in place, that's the only time you can actually go directly at the public entity. Otherwise, they're pretty much shielded by the bond and protected. Okay, next slide. Okay, and so again, before you can assert a claim or file an action on the bond, you have to make sure that you meet all of the qualifications and send out your notices in a timely fashion. And as mentioned, it's very similar to the mechanics lien process. And so if you're somewhat familiar with that process, you're in pretty good shape to start the bond perfection process. But again, you have to be very familiar with all the technical requirements there. But once properly perfected, an action on the bond becomes a great opportunity to leverage a beneficial settlement. Next slide. Okay, so performance bonds versus payment bonds, all right? So property owners typically require the GC of a large project to obtain performance or payment bonds from a surety. Okay, next slide. So essentially a performance bond, the purpose is to protect the owner, okay, in the event that the general contractor does not perform as outlined. If the GC obtains a performance bond and something happens with labor shortage, or they don't have the funds necessary to complete the scope of work, the owner at that point can file a claim against the surety, and the surety will step in to ensure that the scope of work is complete. Likewise, down the line, if a subcontractor is required to obtain a performance bond and something happens and the subcontractor is unable to perform, the GC in turn can also file a claim to make sure that the scope of work is also complete. And the surety has many different options on how they can step in and get the job done. They can contract directly with the replacement contractor to finish the work, or they can actually step in and finance the project as well. Okay, next slide. Okay, now payment bonds, on the other hand, are designed to protect laborers and material suppliers. Okay, if a GC fails to pay for the labor and or materials furnished, then that subcontractor can file a claim on the payment bond. And now this protects the owner primarily because if there's a bond in place, those labormen, they cannot file a mechanics lien on the property and encumber the property. Their recourse would be to go to the surety for payment at that point. Now, payment bonds are often required by property owners so that if they want to sell the property is not encumbered by a lien. So they're free to do so if there is a payment bond in place. Now, in order for a payment bond to stop enforcement of a mechanics lien, the payment bond has to be reported in the real property records where the property is located. So even if there is a bond in place, there are avenues to take a close look at it to make sure that it's valid, to see whether or not a mechanics lien would be effective against it. Next slide. All right, now a subcontractor or material supplier that is dealing with a non-paying general contractor, they can perfect a claim on the bond in a similar fashion to perfecting a lien claim. Now, this requires serving all the notices up the chain. You have to be very careful because you have to send a notice for each month in which you are not paid, okay? So that means you have to make sure you're sending out your invoices in a timely fashion, and your invoices should be detailing exactly what type of work that you performed. And if you're not paid for that invoice in a timely manner, I suggest you send a notice to everyone up the food chain, to the GC, to the owner, to the financing company, anyone that you know that is ahead of you in that food chain should be noticed in that lien. That way, it's kind of the belt and suspenders method to make sure that all your I's are dotted and all your T's are crossed. Okay, and because the process can be very tricky, sending a notice just one day late can invalidate a claim. So it's very important to make sure that all your documents are organized and ready to go whenever you find any kind of payment issue down the road. Next slide. Okay, so we all hate to hear about bonds to indemnify against liens, because usually what happens is we'll have a client who does everything perfectly. They keep great records. Everything's lined up, ready to go. They file their lien, it's in place. We know it's valid, and then the GC bonds around it and now the property is no longer encumbered by the lien, and the owner can sell it, and you lose a lot of leverage. So we hate when that happens, right? If the GC disputes the lien claim, or the general contractor is required to do so by contract, they'll front the money to bond around it, and it's very unfortunate. However, there's still ways to try to obtain payment. It just may take a little bit longer. Next slide. Okay. For instance, for the bond to be effective against a subcontractor's lien, the general contractor must file it in the real property records. And there's also some other requirements that they have to follow in order for their bond to be effective and knock out the lien. Okay, so that's why it's very important to hire an attorney to sit down and look and examine the bond to make sure that it was done correctly. Because if it wasn't, then your lien is still valid and you can still attempt to pursue foreclosure, and it could still jam up the owner and prevent a sale of the property as well. One of the requirements is that the lien has to be of a specific amount for it to be valid. For example, it has to be greater than 40,000, or the amount greater if it's 1 1/2 times that amount of the actual lien, or the actual lien amount plus an additional $40,000. So if they don't get those numbers right, that's a way to challenge the bond and see if you can push the lien through. Next slide. So once it's established that the general contractor actually perfected the bond, let's say we scrutinized it and it looks like they did it properly, the owner of the property, as mentioned, is no longer on the hook, okay, and a sale can proceed. And with the lien no longer a threat, the subcontractor is in a weaker position because the owner is no longer in the picture. They're off doing whatever they're doing at that point, and now you're stuck battling it out with the surety at that point. Now, the surety will be able to use any and all defenses available to it that the general contractor would have. So even if the general contractor is not in the lawsuit, the surety can use all the general contractor's defenses. If the general contractor thinks that the work was defective or there was some other breach of contract involved, the surety, even though they're not in privity of contract with the subcontractor, will be using those defenses to try to invalidate the claim. However, this is why it's so important to keep good records, because if you have all your ducks in a row and that surety sees that it's going to be quite a fight to invalidate your claim, you would be in a better position to negotiate a settlement with the surety. Next slide. All right, so that's all I have for now, but we're going to open the floor to some questions, and I look forward to hearing from you guys.
Thank you so much, Jonelle. Appreciate it.
Sure.
Yes, and as she just said, please feel free to unmute yourself to ask any questions. We're here to answer any and all questions you may have. You can also send us questions via chat, whatever you're most comfortable doing, but I'll be able to ask Jonelle those questions for you on your behalf.
Yes, hello?
Yes.
Hi, we can hear you. Perfect.
Hi, my name is Jim Swindell. I'm with Alamo Surety Bonds here in San Antonio, and we're a bonds agent. And I have a question. We get encountered quite frequently, maybe not a lot, but frequently enough, where it's an issue. And you mentioned it in one of the first slides about general contractors allowing the subs to start the work before they enforce the performance and payment bonds. And usually what happens is they get right up until the time where the first pay application has been submitted, and they're waiting on that check, and the GC says, oh yeah, there's a bond requirement in your subcontract. My question is, since this happens so frequently, is there a point, and some GCs are better than others, obviously, about this, but some are just no good. I mean, some allow a significant portion of the work to start before they enforce the bond. Is there ever a point where the sub has really some kind of recourse against that if they can't get the bond?
You know, yeah, that's tricky. A lot of GCs, they try to keep that in their back pocket, you know, so they can use it as an excuse not to issue that final payment because technically the subcontractor has breached the contract. It all goes back to the terms in the contract that the subcontractor agreed. If there's a clause in there that says that if you fail to meet any of these obligations that are outlined in this contract, you forfeit XYZ rights, it could be tricky, right, to pursue against the GC at that point. So we would have to look at the contract to see if there's any way out of it. Otherwise, there's some arguments you can make as far as just like course of dealing. If the GC knew that there wasn't a bond in place and they allowed that subcontractor to continue to furnish labor and materials, we could try to argue that they waived that requirement because they knew and they allowed them to continue to work on the project. So there's we might have to use some creative strategies to see if we can force payment at that point. But if a subcontractor lets the GC know that, hey, this is unacceptable and I'm going to hire a lawyer and send you a scary letter, the GC might determine that it's going to be too much work and money to fight with them and do the right thing at that point. So, but you have to read those terms very carefully. If that sub signed a contract that gives the GC the right to do that, unfortunately, there might not be a whole lot to do.
Well, I think a lot of it, they don't understand, either the sub or the GCs don't understand that just the fact that the work has already started may prevent them from being able to get the bond. In other words, they may actually be a bondable and they may already be pre-qualified for bonding, but they get into this situation where the general contractor, you know, because they allowed the work to start, now the bond company says, well, we can't do that because, especially like, for example, if a contractor is someone whose bond is being backed by the SBA program, for example, creates a lot of difficulty. And also you get into the catch-22 where the bond company wants the general contractor to sign a letter acknowledging that there's no pre-existing issues with payment or performance before we issue this bond. And then the general contractor's like, well, we don't want to do that because then we waive our right to claim on the bond later on.
Yeah, it's really tricky, and that's why we always advise, listen, if there's a requirement for a bond in a contract, make sure that it's in place before you start the job to try to avoid those kind of tricky issues. But yeah, it can get very complicated.
Right. Thank you.
Thank you.
Thank you so much. We're getting quite a few questions here in the chat as well. We have a question here from Bo Mason Homes. Can its lien be placed on personal property of a borrower of private money lent for a remodel of a flip property that the borrower hasn't paid back yet, long after the sale of the flip property?
Okay, so if I'm understanding it correctly, we're wanting to know if a lien can be placed on a property that, okay, let me start over. A lien can be placed on property in which you furnish labor or materials to, and you have not been paid, okay? Unfortunately, that's the only area you can actually place a lien on. Even if you have a contract with a person, if they have another property over here, you're not going to be able to lien that property based on furnishing labor and materials in that case. So unfortunately, you can only place a lien on property that you furnish labor and materials on. And if that property is a homestead, there's a whole slew of requirements and hoops you have to jump through in order to lien those types of properties.
Okay, perfect. Thank you so much for that. We do have another question here. What is the role of a subcontractor if the bond is not perfected due to reasons unknown, or if the mistakes are only discovered after the performance of one of the parties?
Okay, so let's say there's a bond on a project and you're a subcontractor and you have not been paid by a GC. And you want to know if you can file a lien on the property. You would go ahead and take that bond, to an attorney to look over it and see if it was properly perfected. And if it wasn't, then at that point, you can go ahead and file a mechanics lien on the property if there's not an effective bond in place. If it was properly perfected, unfortunately, your only recourse will be to actually file a claim with the surety at that point.
Okay, perfect. Thank you so much. Perfect. We have any more questions?
I have a question. In regards to like the sequencing and the chronology, it looked like there was like a tight spot right at the beginning of a contracting agreement where a general contractor issues a subcontract to a subcontractor, and if your surety as a general contractor or as a subcontractor isn't generic towards and can apply to specific jobs, that you might have to get a surety that applies to a specific job.
Mm-hmm.
There may be a problem getting stuff done in the right order. What's the ideal sequencing and chronology that should occur, assuming that you're not pre-approved, that you don't have a generic surety as a subcontractor that could apply to the specific subcontract? How should it go, basically?
So ideally in the bid process, the general contractor would let everyone who's interested in working on that project know that a particular type of bond will be required. And then usually there will be a deadline in place. And so potential subcontractors then at that point can contact a bond agent and start the process for shopping around to see if they can obtain the specific type of bond in question. And then of course they can ask for a letter basically identifying their qualifications for obtaining that bond and submit it to the GC while they're considering which subcontractor they want to award the project to. So ideally, that's how the process would go. That letter of credit almost will basically ensure that when you're ready to go get an actual bond, it would be ready and available for you to do so if you are selected for that particular project.
Okay, so the type of surety that subcontractor would get would still be somewhat generic, but specified towards, I guess, whatever particulars the general contractor has, I guess, identified during the bidding phase for the sub.
Right.
The sub. Okay.
Right.
Okay, great question. Thank you. Do we have any more questions? Please feel free to unmute yourself. Oh.
I have one more in case no one else has any. It's just a general curiosity. If the GC applies for a bond after the fact in order to protect themselves from a lien, does that cost more? Since they're, they're exposing themselves and the surety to risk.
Yes, and usually we see that happen when the GC feels very principled in their position. If they feel like the subcontractor that's filed a lien on the property truly does not deserve those funds, in that point, they will go ahead and spend the money to bond around that lien. As I said, those are usually very principled GCs that believe in their position and think that they can actually invalidate any claim that the subcontractor might bring. But yes, they can be very expensive.
Yeah, I would just say that mechanic liens bonds are typically very hard to obtain for contractors, and it's not just the premium cost high, but they also may have to fully fund the actual amount of controversy. In other words, they may have to give the bond company the money in collateral.
Right, absolutely.
So like you say, it's those are not easy bonds to come by. So they have to really not want to pay you to do that.
Absolutely, absolutely.
So it sounds like it's almost self-insurance at that point.
Yeah, basically, that's what we're looking at that point.
It's actually a lot worse than that.
Yeah, they're terrible. But I also have my email address down below. And again, if anyone has any questions later on this week, feel free to shoot me an email. I'll be happy to reply to any email questions as well.
Perfect, thank you. And I just had a question too. I know it's something that we get asked a lot here at the office, but what determines a contractor's bonding capacity?
Right, so this goes back to that letter of credit, so to speak. Whenever they reach out to a surety and request a bond, that surety is going to do some background information, and they're going to request some financial records to see how much that they can actually afford, essentially, and make sure that they have the manpower to complete the scope of work. So that surety, they want to protect their interests as well. So they're going to do some research and look at some financial records to see what the capacity is.
Okay, perfect. Thank you.
I would just say that I'm actually doing a Zoom webinar on that very topic, if anybody's interested.
Hot topic.
I got one more, sorry. I
Sure.
mean, no one else.
Thanks,
Is
Nicholas.
there a way to find out the performance of GCs and other subs in this regard? Like, what's their history? Is there like a, public records and that sort of stuff?
Yeah, I know that there are some more, some information leaning more towards marketing. I know that the Blue Book has a, they list different contractors and with their experience and things like that. But a lot of it is just going to be asking around, word of mouth. If you frequent a lot of the events for contractors and subcontractors, unfortunately, we haven't been having a lot lately. Just get out there and network. A lot of times, the experience and reputation of these companies precedes itself, and word gets around whether or not it's a company that you should be working with or not. But as far as public record goes, you can also do searches to see if they've been sued or if they are a litigious company, if they come across a lot of legal issues. That might be a good way to do some research as well.
Thank you. Great questions today.
As mentioned, feel free to shoot me an email if you guys have any more questions later on in the week, and I'll be happy to write you back.
Thank you so much for your time, everyone. And Jonelle, this is a great presentation. And like she said, I'll be following up with an email with Jonelle's contact information and the handout and presentation from today. So thank you all so much, and hope you have a safe, great rest of your week.
Thank you. Take care, everyone.